Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at a book from Bloomsbury Professional, very high quality publications they are now producing for the legal world. And this book is on the law of limited liability partnerships. It's now in the 5th edition. It's been written by John Whittaker and John Machell, Queen's Counsel, with specialist contributors. And we've given it a title, Limited Liability Partnerships, the Benefits and the Price. Elizabeth was the lead writer on this book, but let's have a look at it first of all. It's a hardback and it's a substantial work in its own right. There's the front, there's nothing on the back, but the spine just shows you the title. And if I open it up, I'll go to the back first. The index is detailed, very helpful. It's by paragraph numbering, so you should be able to find things pretty quickly. All references are to paragraph numbers, it says there in the index. Then you've got, runs to about just under 700 pages. There's an Act of Parliament, of course, the Limited Liability Partnerships Act 2000, which is at the back. If we go to the front of the book, there is the actual front page. You see the consulting editor is John Whittaker, the general editor is John Machell. Then you've got quite a large number of people who are the contributors. I can't go into each person because there are a large number, but thank you individually to all of them. Do read the preface, which sets out why the new edition has come out. It says, now over 20 years since the Act came in. Obviously, while some commentators long predicted the death of partnerships as a model for commercial ventures, continues to be regarded as an attractive option. And of course that's really why I think when the law was looked at some 20 years ago, and I remember it coming in, and how a lot of members of Parliament didn't even know what it was really about, but they could, I think, began to see quite quickly how important it was. So that's the beginning, the preface. Then you've got the actual chapters. You've got an overview of the work and so forth. Then running all the way through, you can see the various chapter headings. Each time I'm doing it a bit slower so you can get some idea of what's in it. There's a lot of stuff, of course, in the book. The various issues that are arising from. It's very, very important for the business community. Then we get into accounts, financial services, sort of in the later chapters, and then we get into things like receivership, insolvency, and so forth, windings up. And then there are a total of 37 chapters, ending with disqualification right at the end. Then you've got an appendix 1, which is the Act itself, and appendix 2 is the other regulations. You've then got the list of cases, quite a lot of cases, of course. And then you've got statutes, all the usual suspects there. And then after that, you've got statutory instruments, even more usual suspects. Then some UK materials. That's basically the codes of practice and various other bits and pieces. Then international materials, which are always very useful for specific countries, actually, which is why it's quite important, starting with Belize, Jersey, India, and ending up with the United States of America right at the end. And then we get into chapter 1. You see the structure of the book. There's the chapter, then you've got the paragraph numbering, and you've got a little bit of footnoting at the bottom all the way through. In fact, the footnotes are quite substantial, and of course directly link mainly to both the statutes and the statutory instruments, and occasionally some case law. But as you can see, running all the way through, it's very substantial work, and a leading authority without any question, in my view, on limited liability partnerships. So what do Elizabeth and I say about the book? This. The LLP is very much a 21st century concept, having come into being via the Limited Liability Partnerships Act 2000, some 20 years ago now. The initial wording of the Act is almost biblical. Quote, "There shall be a new form of legal entity to be known as a limited liability partnership." Shock horror. So you can see there was a very substantial change brought in with this, because for people like me, who had been involved in what we called company law before it became corporate governance, all those years ago, decades before, we then started talking about the limited liability, the creation of a partnership which had restricted its liability. And probably a good thing. I mean, you can realise a limited liability company is aimed at trying to prevent personal liability, and you can see the need with a partnership for something similar, where the people concerned don't want to create a company. So there you have it, you see, with the title. A new day then dawned when this act came in, as the advantages of the LLP met with widespread anticipation and approval. And of course the LLP, however, has predictably created a web of complex regulation and obviously obligation of which participants in this form of partnership must be aware, especially within a legal as well as a social and economic landscape continually facing a process of change. Fortunately, expert and authoritative help has been at hand from Bloomsbury in the pages of what has become the definitive work of reference on this subject, which of course is now the Law of Limited Liability Partnerships, now in the new and extensively updated 5th edition from Bloomsbury Professional. Now, under the editorship of John Whittaker and John Machell, Queen's Counsel, the book provides expert insights and advice covering virtually all aspects of the legislation. For example, there are new chapters on discrimination law and the taxation of LLPs and their members, and there's a new chapter 2 on financial services from Allen and Overy LLP. Additional and substantial updating has also been provided by an expert team of contributors from Searle Court, and of course John Whittaker, I think it's John Whittaker, actually comes from Searle Chambers. Let me just check that, because I think, no, John Machell comes from Searle Chambers, so I must get the names right. Now, with the editorial team, they refer to the protective shield that the LLP affords all members. It also is pointed out that obligations ensue in the form of various regulatory requirements, including the filling of annual accounts with an auditor's report, just like a company would do, and the keeping of a register of members and related materials open to public scrutiny. So there is that element that comes in. But of course, you know, with anything you get, you're bound to have a few obligations to go with all of the other things that you get. Quote, "These and other disclosure requirements," say the editors, "are part of the price which the members pay for the liabilities of the business being borne by the separate entity and for their own personal liabilities being limited." Because this came in at a time when the word entities was being floated in a whole range of different areas. And I could see the sense of that at the time, because it was really trying to protect personal as opposed to business responsibilities for, certainly fiscal responsibilities for what had taken place. And it's added here that the other part of the price for limited liability is that LLPs are subject to the policing regime of the companies and insolvency legislation itself, and so forth. And further details, of course, are given in this excellent textbook. That's towards the end of the book itself. It's about 700 pages long, and there are 37 chapters. It provides extensive tables of cases, statutes, statutory instruments, as well as the UK materials and international materials as well, which I found very helpful, because we are now a global, we're in a global world when it comes to doing deals of any sort, any form of company activity. I do think both the index and the appendices are very helpful, and as an indispensable reference for all the practitioners involved with any aspects of LLPs, yes, you've absolutely got the information here at your fingertips, especially with the new edition, which should be in every practitioner's library. The date of publication is cited at earlier in 2021, and I'm reviewing this in September 2021. There's the book itself again, the front. It's a heavy book actually, because it's a hardback. There's the spine, there's nothing on the back. Just opening it in the middle, we're looking about here the business and affairs of the LLP, conduct and decision making. You can see the structure again, the paragraph numbering, you've got the footnoting on the side, so forth. You should be able to find things very quickly. Just going finally to the back again, the index. The index is very detailed, and it really is something that you should be able to find things quickly. So a big thank you to Bloomsbury Professional for the work you've done in producing this, and I wish everybody involved in LLPs the best of success as we emerge from the pandemic in the 2020s. Thank you to all. Bye bye.